All right, so for Unit 5, where we're headed is we'll do 3 class sessions on that. So this week and next week on Unit 5, which is going to be intellectual property law. And then you'll have 1 quiz for this unit, but it's not due until 2 Mondays away, right? That's the 24th, I think. Is that right? 24th? And you do have a discussion question, though, that I would like for you to do by next Tuesday, because we're going to go around the room. I'm going to ask you to talk about your response. So you will need to have done that by next Tuesday. We'll go over it at the end of class. It's not complicated. That's really all we have for this intellectual property law unit. Not too terribly burdensome, I would hope. You guys have midterms coming up, I guess, the next couple of weeks. Is that right? No? Yes? No, I mean, we don't, but you guys have another. What was your question, Ryan?
Should we wait to do the quiz until?
I would wait to do the quiz until after class Tuesday. I'm not sure what we're going to be doing next Thursday, but I think we'll finish, for quiz purposes, we'll finish the content by the end of Tuesday. And I will make the quiz go live after Tuesday, so you'll have a little bit longer. You'll have a whole week rather than just the 4 days on that. So, haven't looked at grades. Everybody doing okay on grades? Anybody have any big? I mean, not that you're going to raise your hand and be like, I'm failing, but that's really not a good question. Anybody have any questions or observations on how that's going so far? Just curious, it's not due for a while, but who all has gotten their resumes taken care of? Anybody met with the Career Center? You did, Ryan? Had you ever met with them before?
For resume review once.
So was your resume already in the format that they like, or did they do much work to it?
No.
They didn't?
No.
Was it not helpful? You're not going to offend me if you say no. Okay. All right. But it's up to date?
Yeah.
I've seen some of them that they've done, and I think they look really good. So I'm curious. I mean, if y'all tell me that's a huge waste of time, I'd like to know.
No, it's a good service.
Okay.
They're very good with what they do.
Has anybody done their interview yet?
Yes.
How'd that go?
Be prepared.
Be prepared for getting asked hard questions?
Yeah.
Good.
The questions on the form that we were supposed to write in,
Yeah.
actually pay attention to the order that things are presented on there as far as the answers.
All right, so they may ask you some things in your interview they go down the script kind of, or they follow closely your work.
They ask several questions off of that.
Okay, so they ask several questions. That's a good tip. The interview prep that you do, I think, where you write down some things, they're going to ask you questions on. That's good feedback. I appreciate it. I've not had y'all do that before. Worthwhile on a scale of 1 to 10?
The interview, probably an 8.
An 8? Okay. All right.
The resume, I had already had some assistance prior, but I would still put that closer to like 7 to 8.
Okay.
It's beneficial to do.
That's what I like to hear. Who all has finished their handshake profile and setup? Y'all already have it? What about LinkedIn? Finished? Got those already? I see some of y'all trying to be friends with me on LinkedIn. I don't pay attention to it, so if I didn't respond, don't be offended. I can't remember the last time I logged in on LinkedIn.
I made another email specifically so I don't.
Do y'all smell that? It smells like heat being turned on. All right, my people on the video are saying, get to it, Professor. Let's go. So let's get to what we're here to talk about. Intellectual property law. So this is, as we do in this class, we take different areas of the law and study them for a week or two and then move on. Intellectual property law is an area of civil law that protects the fruits of our intellectual and our creative work. It allows us to make sure that things that we create, that we invent, that we write, that we come up with, can't be stolen or used by somebody else without our permission, right? Pretty important. You see intellectual property all around you. We're going to talk about trademarks. You can look at the back of my laptop and see a trademark. I can hold up my drink cup and you see a trademark. I see trademarks everywhere I look this morning. We'll talk about those. Patents, used generally protects inventions and formulas and recipes. Trade dress, the way that a product is packaged or presented, also protected. Trade secrets, proprietary or confidential information that a business owns that's unique to them that would be valuable to a competitor, that's protected as a trade secret. And then copyright, which protects things that we write, like a poem or a play or a movie or a song or a photograph or a painting, things like that. So we'll take them in order. Let's go with trademarks first. Trademark, by definition, is a distinctive word, symbol, or sound design that identifies a certain product with a manufacturer. So everybody Google example of trademark and hit images, see, and then holler out what comes up. You should be raining them down on me when they come up. What do you got, Miss Castillo? What comes up? Chanel logo. All right, you've seen that. Kim? Nike, that swoosh. Just Do It. That's also trademarkable. Yes, ma'am. McDonald, that M. Yeah. You recognize that right off, don't you? What else do y'all see come up? Ford. Good one. What you got? Starbucks. Absolutely. Miss Mormon, what do you got? Subaru. There you go. That's one. They're everywhere. Trademarks are everywhere. The sound that Law and Order makes, the cha-ching thing, that could be trademarked. They're everywhere. They're protected from being copied or being tarnished or being confused, and we'll go through that a little bit in a sec. You can register a trademark with the U.S. Patent and Trademark Office. It's advisable to do that because if there's ever a dispute about who came up with something first, the person that got it registered with the federal government would have pretty good evidence that they were first. But you don't have to. I could create a trademark for my law office, but I would never register it. But if somebody copied it, I could sue them for it. It would be harder to prove. It'd be a more difficult case, I think, if I haven't registered it. But you don't have to do that. But it's advisable to do that. Most trademarks are registered. You see the little TM in the circle down there, buy one that indicates that it's a trademark and that it's protected. In order to be protected, a trademark has to be either very unique. I'm going to give you a bunch of examples. Very unique to that product or business, or it has to have become associated with that product or business long enough over time that even though the name is not unique, we associate that name with the product. So it kind of goes on a scale from most original to least original. The most original trademarks enjoy the most type of protection. The more likely it is they'd be protected. So think about the highest level of protection would be fanciful trademarks. Those are made up words. They don't have any independent meaning outside of that product, like Exxon or Xerox. I got a list in my notes too. Google, that has no independent meaning outside of that company. Rolex is not a real word, but we all know that means the watch. And those are fanciful trademarks. Arbitrary trademarks are something like Apple computers. The word Apple in and of itself is generic and is not trademarkable. But Apple, as it's associated with computers, is unique. It's arbitrary. There's nothing about the fruit apple in a computer laptop or whatever it is from Apple. There's nothing that they have in common. But Apple could trademark the Apple as it relates to electronics because that's unique to them. So the more unique it is, the more likely it is to be protected. Dove soap. The word Dove in and of itself is not trademarkable. It's a generic word. But Dove soap is, because there's nothing that a bird has to do with cleaning a bar of soap or a thing of soap. Melanie.
Isn't there an ice cream called Dove too?
There is an ice cream called Dove, and that's a good. I'm glad you brought that up. So, it is. It's like the ice cream bar dipped in chocolate. Is that right?
I believe the chocolate brand is Dove.
Okay. Okay, gotcha. The chocolate brand is Dove. He says. I think that's right. Can two companies have the same name? I mean, they can, as long as they're not using the same design, logo, that they're not confusing with each other. Now, another soap company couldn't come in and be Dove. That would be too confusing, too much like Dove soap. But are we is the consumer likely to confuse Dove soap with Dove ice cream? You think so? If their logos are similar, maybe. If they're totally different, maybe not.
I saw somebody eat a bar of soap on TikTok because they said Dove and they thought it was an ice cream.
Oh, God, okay, what, y'all remember what's my number one rule? Most people are what? Idiots. We've talked about that. For my video watchers, she said somebody on TikTok ate a bar of Dove soap because they confused it with the ice cream. That's really sad. But to illustrate the point, it would be a lot easier for companies that have unrelated products to have the same name like Dove, but there is no world where somebody could come in and have Rolex ice cream or Exxon ice cream, because that word is only created and associated with those products. So that would enjoy more protection than Dove would. As we go down the list, you get from more specific to more general. There's suggestive trademarks. Airbus manufactures airplanes, but the word air and the word bus are generic. There's nothing unique about them, but you put them together and we can associate that with the airplane manufacturer. Words that are descriptive, we're going down the list, so we're getting closer to generic. Words that are descriptive are a lot harder to trademark unless they have just been associated with that brand for so long, like Sharp Electronics. The word Sharp is generic, be hard to trademark. But we do now associate Sharp with that brand of electronics. They've been doing it so long, calling themselves that we could see where that would be protected as it relates to their products, not overall. Holiday Inn, that's pretty generic terms individually. You put them together, that's become associated with that hotel chain. We're all pretty familiar with that. That would be something that could be trademarked. Then you get all the way to the bottom of the spectrum to the just generic stuff, and you can't trademark generic words like clock or donut, coffee. Not trademarkable. Why is Coke trademarkable? But coffee would not be. Why is the word Coke trademarkable, but the word coffee isn't? Because Coke is a made-up word that only relates to Coca-Cola. In the soft drink sense, we're not talking about cocaine. I should have been more specific. Should have been more specific. Have y'all ever heard the song Cocaine Bear by Yarn? I heard it this weekend. It's not a new song, but it's awesome. Not because it's about cocaine. It's just a good song. Anyway, that was way off topic. All right, so once a trademark is distinct enough to be protected, what is it protected against? Well, it's protected from being copied by somebody else. And that's called infringement. Trademark infringement is when we use somebody else's trademark in a way that we are intending to confuse the consumer to think that our product is related to theirs. Trademark infringement, if it's an exact copy, that's an easy case. All right, if I make t-shirts with this on it right here, this exact design, that's trademark infringement. I'm straight up hijacking their trademark. If I make t-shirts that are similar to this, the design is a little bit different. Maybe there's 3 dots on top for the chicken's comb instead of 4, or I don't have the eye, or I do the beak differently. I'm not straight up copying it, but if I'm copying it in a way that confuses, where the consumer would say, you're either trying to rip off Chick-fil-A or you're trying to look like Chick-fil-A, that'd be trademark infringement. Trademark dilution, dilution, like you dilute something to make it weaker, is similar to trademark infringement, but it's not a straight up hijack. It's more suggestive, more likely to confuse the consumer, more likely to tarnish or muddy the reputation of the brand. There's a case, a famous case, where a Korean fried chicken restaurant called themselves Louis Vuitton Duck, or DOK, something like that. And it was a play on Korean words, which I can't tell you exactly. But they used the Louis Vuitton, the LV logo on their restaurant. So Louis Vuitton sued them for infringement, for copying their exact logo, but also for dilution, because the Louis Vuitton duck is not the exact same word as Louis Vuitton. So that would be more dilution than infringement. And then they got cute, and Louis Vuitton duck tried to change their sequencing of the letters, and then Louis Vuitton sued them again. Anyway, the Korean company lost that. If I'm Gucci, I own Gucci, and somebody makes a brand of toilet paper called Gucci, but they spell it Guccie, and they don't use my logo, but they've used that word. That's not infringement. It's not spelled the same. They didn't use my logo, didn't use the same font or anything like that. But that might be trademark dilution if I could convince the court that consumers are likely to confuse that with my brand, my high-end clothing brand. Now, if you are the manufacturer of Gucci, Guccie toilet paper, and I sue you for trademark dilution, what's your defense? What, Ryan?
It's not even in the same.
Not in the same realms. Toilet paper and designer clothing are not the same. Now, if I'm Gucci's lawyer, what's my response to that? Still confusing. A consumer still might think that I'm in the toilet paper business. They're still trying to piggyback off my name. Incidentally, if I sue Gucci toilet paper, who's going to make the decision about whether or not they have infringed or diluted my trademark? The judge or the jury, if we have a jury trial. If we have a bench trial, just the judge. So these things are always going to be judged by the court. It's going to be in the eye of the beholder. If I look at, if it's a straight ripoff of a logo, that's pretty easy for me as a juror to say, yeah, you're copying them. But in trademark dilution, like the toilet paper versus the clothing line case, it's a little bit harder to tell. But if you have a trademark and you want to enforce your right to keep it from other people using it, the way to do that is to go to court, which, as we've talked about in here, is not easy, is not cheap, is not fast. What are some reasons that you might want to sue somebody for trademark infringement or dilution?
Loss of business.
Yeah, it might be hurting your business. What would you ask for, Xavier? What kind of damages would you want? Compensation in the form of lost profits, or how about money that you're making off of me? I want a cut of what you've made by stealing my idea or design. What else?
To dissuade other people from doing.
Yep, to warn other people, don't mess with my brand. You think you're cute. You're a little Korean restaurant somewhere in Korea. You just have one restaurant and you thought it was cute to name it Louis Vuitton. I'm coming after you. Don't do it. What's another reason you might sue somebody for it? If you don't sue them, what are they going to keep doing? Keep using them. You can sue them to stop them. Right. So there is some incentive to do it. All right. That gets us to trade dress. All right. Let's do the same thing that we did with trademark. Google trade dress example and then hit images and tell me what comes up. The bottle Coke is a great one. That green glass bottle with the wavy, the way it is. So we couldn't trademark that because it's not graphic. It's not a word. But it is protected if it's unique to that product. They invented it. It wasn't already out there. And we associate it with them. So the Coke bottle is a great example of trade dress. What else do y'all see? The Heinz ketchup bottle be in that shape, so I can't, although, I feel like ketchup bottles are all shaped kind of like that. That'd be a real interesting thing to look into. But you're right, the exact Heinz ketchup bottle.
Shoes.
What kind of shoes, Xavier?
I see some Adidas right here and some Converse.
For trade dress?
Yeah.
So the way that
And heels.
okay. All right. Here's one, the Tiffany jewelry box that's that color blue wrapped in the white ribbon. So think about that for a second. It has to do with the combination and the use, the specific use. Like if I made a logo for my law firm that would use that color that Tiffany uses, I mean I'm not infringing on anything of theirs. That color is belongs to the public realm. Anybody can use that color. But if I use it on boxes of jewelry tied in white ribbons, then now I'm copying their trade dress. That might be a violation. To put jewelry in a box, not a violation, that's common, right? But to put it in a turquoise box with a white ribbon, now we're kind of getting there. Anybody see anything else on trade dress that was interesting? A Happy Meal. That's a great one. Happy Meal coming in the little box. What else, y'all see? Anybody see anything else?
Fish.
Goldfish? That bag?
The fish itself.
The fish itself. Huh. I guess that wouldn't be a trademark. It wouldn't be a okay. Okay.
It was one of them.
I see it. That's it. Okay, I'm glad you brought that up.
This is like a question more so than
Ask away.
but like the University of Georgia, the G, and then like Grambling State, they both kind of have, and the Green Bay Packers, G.
So that's a great question, Ethan. These sports teams, how do they get away with having them be similar? I'm not sure in Georgia's case, the case of Georgia and Green Bay and Grambling. But what happens is, and there are a lot of intellectual property disputes between sports teams. What they'll end up doing is licensing it to the other people. Meaning you can use it, but you got to pay me for the right to use it. And that makes a lot of sense in intellectual property. I don't want somebody tarnishing my brand, right? And I don't want somebody making me look bad. But if somebody's making money off of using my name in a way that's not confusing or not negative to me, then I'm all for that, as long as I'm getting a cut. So a lot of times in intellectual property, disputes get settled by a licensing agreement. Okay, fine, you can use it, but you got to pay me for it. Fine, we'll do that. There is a story behind that Georgia G, and I'd have to look it up. I'll look it up and tell y'all. That's a great question. The 12th man, the saying 12th man that Texas A&M thinks they invented, and then the Seahawks used it. I think the Seahawks ended up having to pay Texas A&M to license it and use it or something like that. Great question. Your outline talks under trade dress about counterfeit goods. So let's distinguish that for a second from infringement. A counterfeit good is when you're straight up copying somebody else's product and you're passing it off as the exact same. You are infringing on their trademark, yes, but you're also counterfeiting. You're defrauding the public into thinking that that's something that it's not. Counterfeiting could be criminal. I think it can be civil too. It's probably a tort and a crime. That's a little bit different flavor of violation than trademark infringement. All but just as illegal. Patents. Patents give the inventor or the owner of an invention, of a formula, of a process, the right to make it, to use it, to sell it exclusively for a period of time. Trademarks can go on and on forever. Nobody can ever hijack Coke's trademark unless Coke went out of business and stopped using it or something. As long as they want to stay in business, they can keep that trademark. Patents, on the other hand, do expire. You don't need to know for quiz purposes what the rules are, but it's somewhere between 14 and 20 years, depending on exactly what it is. But after that first period of time runs out on your patent, then it becomes available to the public. So this is why you see like prescription drugs. If a drug company comes up with a specific formula for a drug and they get a patent on it, nobody else can use that. But then when that patent expires, everybody else can. So it's a huge boon to the drug companies when they invent something that they get a patent on, because for 20 years, they're the only people that can sell it. So they can do what? Jack up the price on it. Nobody else has it. And then once that patent runs out, everybody starts making it. Then we get the generic forms of medicines and things like that, and prices can come down because now all of a sudden we've got competition on it. But that's a big, important deal for drug companies to be able to get patents on their formulas so that they'll have exclusive use to sell it. Google famous patents or example of a patent. Tell me what y'all see. Winnie the Pooh?
Yeah, their patent ran out and someone did a worm.
Oh, that's true.
They lost Mickey Mouse too.
That's true. But I'm trying to think about why that wouldn't be protected as a trademark. I guess Winnie the Pooh is not the sign of a business. It's a creation, an artistic creation. What you got, Janeway?
Light bulb.
The light bulb. Good. Xavier? The Monopoly board. Patent on that. Bluetooth. Winnie the Pooh is a great one. That's right. And then somebody made a horror flick, right? Cartoon. Horror. Where was Winnie the Pooh the slasher? Was he the bad guy? Did they? And they sued him? No, they didn't sue him because the patent ran out, right? So it became. So when a patent runs out, it goes what they call public domain. Once it becomes in the public domain, it's fair game. Why did Mickey Mouse ran out as well?
Yeah.
Huh.
Both movies suck.
What'd you say?
Both movies suck.
Both movies were you watched them?
I watched it.
Somebody made some money off of it, though, didn't they? Right? Okay, good. Anybody else got any more famous patents? Yes.
Electromagnetic motor.
Electromagnetic motor, good. We think about patents more, we tend to associate them more with inventions, but a thing like Winnie the Pooh or Mickey Mouse would be patentable. The Monopoly board is a great example. That's not really an invention, but it's a game board that has a unique enough design. We would trademark the name Monopoly, right? But we would patent the design of the game board. Good. Anybody got another one they want to throw out? Yes.
Was it the Iron Lung patent?
Iron lung was probably patented. Medical devices get patented. Drugs get patented. All kinds of inventions along with like automobiles, all those things can get patented. Now, if I'm a drug company and I invent a drug that cures cancer and I have a unique formula for it, I get a patent on it. My competitors are not just going to sit back and wait 20 years. What are they going to do?
Try and make their own.
Try and make their own how, Xavier?
I guess in a way that is different from.
In a way that is different from mine. Like, how can we tweak the formula in a way that doesn't straight up hijack his or copy his? So when you get into patent litigation, it can be very technical. I'll tell you, if you want to put me on a jury on a trademark case, fine. I can look at this trademark and that one and tell you what I think. You want to put me on a jury about the differences between the formulas in prescription drugs? No, thank you. Apple and Samsung sued each other about patent infringement for the design and user interface of their phones and all that kind of stuff. Leave me out of that. I'd be lost in the first minute of that trial. If you're Apple and Samsung and you spent millions of dollars litigating over the technical specifics of your phones, are you really excited about going in front of 12 citizens to decide your case? I wouldn't be. There's billions of dollars at stake, and we're getting 12 people not off the street, but 12 regular citizens. And we're going to make them listen to weeks and weeks of expert testimony on phone design and intricate electronic details. I don't think I'd be a good juror for that. Patents do have to be registered. So with trademarks, you don't have to, but it's a good idea. Patents, you do have to register them with the U.S. Patent Office. It's searchable. If you have a design, most people that want to get a patent on something go to a intellectual property or patent lawyer because they know how to search the database and give you an opinion on how similar or different your product is or your design or your invention is from stuff that already has a patent on it. They'll give you advice on whether or not they think you should apply. And then if you do want to apply, they'll do the application for you. It has to be approved by that patent office. Things that are not patentable, and we've thrown out a lot of examples of things that are patentable. Invention, discovery, process, design. We cannot patent the laws of nature. I can't patent lightning. That's not mine. I didn't invent that. I can't patent shivering from a cold classroom. Just a phenomenon of nature. I can't patent happiness. There's no formula for that. There's no specific formula for that. I could come up with some ingredients, probably, but there's no specific formula for that. So abstract ideas like peace or happiness, things like that, you can't get a patent on. patent infringement, we talked about that a little bit. Much, much harder, I think, than a trademark infringement case. And costly, complex, very technical in nature. And another example of where licensing is a great resolution to a dispute, a patent dispute. Okay, your drug the formula is a lot like my cancer drug. I'm not happy about that, but it's different enough that maybe I'm not positive I'd win the lawsuit. So I tell you what, how about I license it to you and we'll share in the profit? Good way to settle it. All right, copyrights is the next area we're going to look at. So copyright is protection that's afforded the result of someone's creative process. So a poem, a novel, a nonfiction book, a painting, a photograph, a play, a song, a certain sequence of notes, maybe not even a song, but a chorus, a sculpture, a movie. All those things enjoy copyright protection. Unlike trademarks and patents, we don't ever have to register copyright. You create something and publish it, and it's yours. Nobody else can use it without your permission for commercial gain. Most of the time in copyright, it doesn't get ripped off straight like we might in some other areas. If I write a 1,000-word poem on the wind, what are the chances that somebody else is going to come up with that exact same 1,000-word poem on the wind? Not very likely. But they might come up with a line that's same as mine, or a couple of lines that are same as mine. And that might be a violation of my copyright, even if it's not exact. Exact copyright infringement is just sort of straight up plagiarism. Or just theft, right? If I take Mr. Janeway's book that he wrote, word for word, and put my name on it and sell it, that's copyright infringement for sure. That's easy. If I write a story, though, that's similar to his characters, the plot's similar, the names are different, the plot's not exactly the same, the ending is different, he still might could sue me for copyright infringement. It's just not an easy case. It'd be up to who to decide whether or not they were similar enough. Who, Miss Melanie?
So Disney lost rights to their copyright expiration expired for their Steamboat Willie, not exactly the Mickey Mouse. He's technically a trade.
Right. So she brings up a great point. Copyrights do expire. And it's usually, and you don't need to know this for testing purposes, it's usually the life of the person plus a certain number of years. 70 years, something like that. So the person, the author, the creator's estate even would own the right to that copyright after death for a certain number of years. Steamboat Willie, which was like the first Disney creation, right? Something like that. It's finally gotten old enough to where the copyright ran out and it's become part of the public domain. Anybody can use it. There is an article that I've assigned you for Tuesday that talks about the song, the Blurred Lines song. Have y'all ever heard of this controversy? So that Blurred Lines song by Robin Thicke, it's a few years old now. But Marvin Gaye's estate sued Robin Thicke for copyright infringement. And it's not the same song, but they allege that there's a sequence of notes in Blurred Lines that is similar enough to the Marvin Gaye song, whose name escapes me right now. Got to Get It On or something like that, maybe. Anyway, I'm gonna play it for y'all on Tuesday. You can listen to it between now and then, but We are going to talk about that case and sort of some of the ins and outs of that. In past classes, I've assigned you the exact case to read. What I've given you for blurred lines is actually an article that somebody else wrote on the case. But I've published it. I've used it to our content module. So have I violated the author of that article's copyright? I'm using it, right? I'm using it. But there are exceptions to copyright infringement. One of them is called the fair use exception, and educational purposes are one of those. So it's okay for me to do that. Now, I couldn't reproduce a textbook. I couldn't just give you a link to an electronic textbook and say this is a fair use exception. That'd be crossing the line. But the article, using an article for educational purposes is not. Some other examples of fair use are if I'm a movie critic and I have a television show or a YouTube channel where I critique movies and I show a clip of the movie as part of my review, that's okay. If I'm a book reviewer and I put an excerpt of the book, maybe a paragraph or a sentence, or I think that this particular writer uses a great style and I give some examples of that in my book review, that's okay too. I can't use chapters of a book or long passages. At some point, it crosses the line into copyright infringement. Usually where that line will get drawn is, or one of the most important factors in the lawsuit is the person making money off of it? Are they using it for their own commercial purposes? Right? When that happens, that's not fair use. That's me profiting off somebody else's creative ideas. And that doesn't fall within a fair use exception. Copyright infringement. I thought that was the last one, but I lied. So there's trade secrets that I want to talk about as well. Trade secrets are something that's proprietary, confidential, unique, created by that business, within that business. It's not public knowledge, not public information. And if it's used by a competitor who obtained it without permission, then that's theft of trade secrets. This happens more than you would think. When employees leave one business and go to another, sometimes they'll take some of the stuff they learn with them. And so think about, like, as an example, maybe I own a drug company and I haven't yet gotten the cure for cancer, but I'm close. And Alan is one of my research guys, and he leaves me and goes to a competitor, and he takes the research that we've done and he goes over there and they figure it out. They get to the finish line before we do. If he's used my information, then he's stolen my trade secret. Now, research goes on all the time everywhere, right? It doesn't mean that one person, just because you're researching something, that you've got the exclusive right to the solution or the cure or whatever it is. A lot of research becomes public, is shared. That's okay to use that. But when we use it in a way that it was not public or it wasn't ours to use, then that would be theft of trade secrets. Do you have a question?
Is this pretty much only applying to information?
I would say yes, it applies to information, but it applies to the way that information is aggregated or arranged, like research, customer lists. If I have a customer list of my customers, I can't trademark that. It's not a logo. It doesn't describe my business. It doesn't represent my business. It's not copyright because it's a list of people's names. It's not, it's not a result of my creative process, but it's something that I compiled over time that is unique and sensitive and private to my business. So yes, it is mostly information, but it's the way that that information is either gathered or aggregated or assembled, pricing information, marketing techniques, things like that would be trade secrets. Now, I would tell you that probably things like the formula for Coke or the Colonel's Secret 11 herbs and spices or whatever, I mean, those are trade secrets. But if those businesses are smart, they could also get patents on those. So if you could get a patent on it, I'd get a patent on it and not worried about it being a trade secret. There's some overlap to that, I would say. But that'd be really getting into splitting hairs, I think. Now, if I'm not careful about guarding my trade secrets, if I'm reckless with that information, if it gets published, if I have a Zoom meeting where we're talking about some top secret formula, but I've not protected it from the public being able to come in my Zoom meeting, and somebody gets it, if I send an email accidentally out to people that I didn't mean to, that's my fault. So you do have a duty as a business to reasonably guard the confidentiality or the secrecy of what it is you're trying to protect. Similar to what you were asking about, is it basically information? Thinking about copyright for a second. Sometimes you can get a copyright on things that individually by themselves would not be copyrightable, but the way in which you've compiled them is. So for example, the Guinness Book of World Records. Maybe I set the world record for holding my breath the longest. I don't know. I can't get a copyright on that. Anybody can everybody's free to hold their breath for as long as they want. And if they can break the record, awesome. I can't get a copyright on that. But if I have a book that has compiled a list or a group of the various world records, then somebody can't rip that off. They can't republish that as their own. So an aggregation of facts, whereas a fact itself can't be copyrighted, an aggregation of facts could be. Who has questions on that? All right, so I'm not wrapping up, so don't pack up yet, but I am concluding the lecture portion of this. The discussion question for this unit, I would like for you to do on Monday, because Tuesday in class, we're going to go around the room and you're going to share your response to the discussion question. I'm going to read it to you as soon as my laptop connects to the internet. All right, your Unit 5 discussion says, please research the internet just like we've done in class today. Google is fine. For one example of a real-life case involving trademark infringement, trademark dilution, copyright infringement, patent infringement, trade dress infringement, theft of trade secrets. Just find one example of those. And then in your response, and what you're going to tell us about in class, you're going to tell us who the parties were, what kind of case it is from the list that I've given you, what the dispute was about, what was their beef, what was the controversy, why did one party sue the other, any interesting facts, comments, or observations that you have. Now, this is any interesting facts, comments, observations that you have, not Mr. ChatGPT has. I want to know what you think. Okay? This is not a hard assignment. I just want you to Google an example, but I want you to be familiar with the facts of what it was so that you can tell us about it. And if you see something interesting, that you can share, that you can relate to, what we've studied, that's excellent. You might want to peruse what everybody else has done. Some people have posted to keep from doing a duplicate. It's okay if we have duplicates. That usually does happen. We're all Googling from the same place, so we're going to get some of the same things. But it does make for more interesting discussion if we have different examples. I promised you in Unit 2 that I would answer some of your questions about the law, and because we've got about 10 more minutes, I'm going to do some of that today. So, here's a good question. Do you have any critiques when watching crime TV shows like Law and Order? Ms. McFauley, this is your question. Were your nerves bad? Oh, well, that's the second question. Let me take one of those. Well, she got a lot of questions. So, yes. I have they're entertainment. And so from that standpoint, I don't really have a critique because I know going into it that it's not real. Like, you watch Law and Order, that's 48 minutes after commercials of content, and we're going to solve complex legal cases like murder trials and things. It just doesn't happen that fast. The sudden swings of momentum, or just them finding witnesses at the end of a trial out of the blue that are going to sway the case one way or another, that really doesn't happen much in real life. But I do think that a case like Law and Order does a pretty good job of getting into the technical aspects of things. You do hear a lot of real legal arguments on that. Like, if you watch Suits, there's not much real legal anything about Suits, which I like Suits. I think Suits is entertaining. But Law and Order probably comes close to the most realistic in terms of that. So I don't sit there watching them saying, that's not true, that's not true. I do think to myself, that's not how it works, but it doesn't bother me. But I know better than to substitute that for real life. Were my nerves bad when I first started? Absolutely. I was scared out of my mind sometimes when I'm going into court to argue for the first time. I'll tell y'all a quick story. I had just gone out on my own, and I had rented an office from this lawyer who was a lot older that I knew and liked, and he was kind of my mentor. And so I rented an office from him so I could have somebody to ask questions about, sort of model my practice after his. And he went to Spain for a couple of weeks and said, I need you to go to court for me while I'm gone. I had just started and handle this case. And it was a magistrate court case from Harris County where two people who were fighting over custody of their child, they weren't married, had sworn out peace warrants against each other because they got into some argument about when they were going to exchange the child. So I had to go up there and defend this guy against the peace warrant that the baby mama had taken out, and I think he'd taken one out against her. Well, my friend was like, just go up there. I mean, there's nothing to it. I can't remember what he told me. Well, the judge ended up arresting or ordering both parties to jail. And I was like, oh, how am I going to explain this? I went in there and defended your guy. He got put in jail. But it ended up that the judge at the end was like, all right, I'm going to let him out. I was just trying to teach him a lesson because they're both being ridiculous. And I was like, phew, thank goodness. So I did. But the worst nerves there were nerves when I started. But in law school, you got to do a lot of arguing in front of law professors where you're practicing this kind of stuff. And that was worse than anything because I knew they were a lot smarter than me. And it wasn't a setup, but I mean, they were the ones that created the sign. You know what I mean? Like they had listened to this argument many times. It wasn't a fair fight. And so that terrified me. But then going to court was not quite as bad, but then there were other people watching. And then I don't know. So that's a great question. You have some more, but I'm gonna come back to them so I can get some other ones. What is the most interesting case I had to deal with? It's Miss Lagon's question. She's nodding over there. So this is I have a good answer to this question. I don't know if it's the most interesting, but the most weird, like you can't make this stuff up type thing was that this has been a couple of years, there was a birth mother who wanted to give her baby up for adoption. So she got with an adoption agency out of Atlanta and worked with them, had the baby, picked out a set of adoptive parents that were going to adopt it. Baby came, the baby went with the adoptive parents, and all of a sudden this dad showed up out of nowhere because the mom is supposed to disclose who the dad is and all this, and she wasn't truthful about it. And she also tried to get back with the dad. So when she did that, she's like, yeah, I'll help you defeat the adoption, because she was back with him. Long story. So he tried to fight the adoption, and the adoption agency hired me to fight the dad. And I did, and that was in a case here. And so the dad was just batshit crazy. And I mean, like, not like diagnosable, like somebody's schizophrenic. I mean, like, but the kind that you're like, I know crazy when I see it. You know what I mean? Like, he could function in society. But he was crazy. So one of the things that he had done that was crazy, I've never come across this in my entire career anywhere. He pretended to be a doctor and set up a medical practice in Columbus. He was treating people. Now, I mean, I would have to say that the people who went to him, that really was on them, because there's no way that anybody would have. But he had a white coat with his name on it. He had the people coming by every week to pick up his disposable toxic waste. I mean, he had a provider number that he'd registered somewhere. It didn't last long. He ended up getting prosecuted for it. The government found out, and that unauthorized practice of medicine is a crime. And he spent jail time on it. While he was in jail, he would write letters he had baby mamas all over Georgia and Alabama that he had told different stories to here and there. And one of them was, of course, this lady that I was working on this case. But he had written her a letter from jail talking about how I need to bring it. I can pass it around. But talking about how much he loved her, but also how he couldn't wait to get out of jail and murder her with a box cutter. And it would say things like, but no offense. Like, no offense, but no offense. But it concluded with a long declaration of his undying love for her and all that. I mean, just crazy stuff. He's not in prison right now, I don't think. But he was a musician. He claimed to be a pastor at a church in Atlanta. And I took his deposition. I'll bring that to show y'all. And it was like, where are you a pastor? He would tell me, I'd be like, all right, let's Google that. That's a parking lot. No, it's not. Yes, it is. No, they do. Who's your boss? So, I mean, he was a compulsive liar. He just would keep on lying. He would never admit that you called him lying. He would just make up more lies. So that was one of the funnest cross-examinations I've ever had in my life, was when we got to trial for that case. And I got to put him on the stand and take him through all of the lies that he had told. And we didn't even go through all of them. At one point I was like, Judge, I've got like pages more, but by this time the judge had already he knew this guy well, and he was licking his chops for a reason to deny the guy's claim on the baby. But that was maybe one of the most interesting in terms of craziness. Also, one thing that was funny was I had a divorce case one time where my client had cheated on her husband, and the husband's lawyer was taking her deposition, and he told her to list everybody she'd had sex with besides the husband. And she was real proud of all the people she had had sex with outside her husband. And so she was a baseball groupie. She was a professional athlete groupie. And so one of the names she gave was Robinson Cano, who at the time played second base for the New York Yankees. I knew that because I was a baseball fan. But the other lawyer was a giant nerd, and I knew he had no idea who that was. And he kept asking her questions about it. Like, who is this Mr. Cano? Where does he work? And she would give out little tidbits of answers. And it took him forever to figure out, finally get it out of her that he was a professional athlete. And the whole time I wanted to be like, the guy plays for the Yankees. Can we get, she's real proud that she slept with one of the Yankees. But I just sat there and let him figure it out. But that was, stuff like that would happen all the time. I didn't really enjoy that part of it. So anyway, I do have other cases that are maybe a little more interesting than that. But that's my first answer to that. You've got some other good questions, Ms. Lagon, that I'll answer going forward. Whenever we have extra time, I'm going to try to do this. So that concludes today. You do not have a quiz due on Monday the 17th, but you do have a quiz due Monday the 24th. Next Tuesday, we're going to talk more about intellectual property. The quiz will go live on Tuesday because whatever we do next Thursday is going to be different than intellectual property. So I will see y'all Tuesday.